My name is Richard Fine. I'm a strategic consultant, and I'm talking about judicial corruption. No. Okay. Now, in 2000, now at the time that this occurred, which was November 1999, I did not know about the payments being made to the LA County judges. In September 2000, and particularly on September 15th, 2000, California Chief Justice Ronald M. George announced or stated at the annual meeting of the California Judges Association in San Diego that he thought the payments to the judges were wrong and maybe unconstitutional. That statement was printed in the Metropolitan News. I picked up on that statement, and that's how I found out about the illegal payments to the judges. No judge had ever talked about these payments. It was a well-kept secret. In the appellate brief in the Silva versus Garcetti case, I exposed those payments for the first time. I was the first lawyer to do this. What happened is the appellate court said, well, too bad, you didn't do it before. Of course, I didn't know about it before, but that doesn't matter to us. We could care less. I then came back in 2002, because that appellate case was going on through 2001, and in 2002, I brought the first lawsuit of Laqueos versus the County of Los Angeles against Judge Kurt Lewin, who had not awarded the attorney's fees, and I sued Kurt Lewin and the County of Los Angeles for the illegal payments, seeking to stop them, claiming that they were a violation of Article 6, Section 19 of the California Constitution. And that article says that only the state legislature can prescribe the compensation of the judges. I also sued them for violating the U.S. Constitution and various parts of its due process and so forth. That case got dismissed on procedural grounds. I then filed a second case in June of 2002, which was the case of Silva versus the various judges, Judge Chalfant, Judge Doy Todd, Judge Boren, Judge Knott, and Bruce Mitchell, and it was a defendant's class action case against all the judges for taking the payments, to enjoin them from stop them from taking the payments, to stop all the payments, and on the same grounds, Article 6, Section 19, in violations of the various constitutional clauses. That case also got dismissed on very strange constitutional grounds. The judge said that Silva didn't have what they called Article 3 constitutional standing. Now, Silva did have the standing. He already had a divorce case going. He clearly had the standing. The federal court was now trying to protect these judges. So both these cases got dismissed on standing. However, the judges never denied in these cases that they were breaking the law. So we now have the second thing happening. The next thing that occurs is that this becomes sort of a phase 2 secondary retaliation, because we now have the federal courts involved in protecting these judges. In 2004, I was retained by the Coalition to Save the Marina and the Marina Tenants Association and others to bring cases against the County of Los Angeles and various developers with respect to the illegal leases in Marina del Rey. Now, Marina del Rey is the largest private yacht harbor in America. It has approximately 6,000 boats, and it's approximately 800 acres, 400 acres of water and 400 acres of land. The County of Los Angeles leases out the land to private developers for development. This is an illegal lease, because what the county is doing is the county is giving the land to the developers, who then put apartment buildings on the land. Now, under the law, that particular use is illegal because it's a permanent type of use, and you can only really lease the land out temporarily. It's a violation of the California Constitution that says that you can't give out public land to private people for use. We brought the suit on that ground. However, there was a second part. The developers put apartment buildings on the land, and what happened is that the developers were earning approximately $325 to $350 million a year in income from the land. The county was only getting $35 million a year from the land. Normal commercial leases in this type of a situation would show that when you have the land and the apartment building, the landowner was getting should be getting approximately $100 million a year based upon this type of land and the land value. And we showed that this land was worth so much per square foot, so much per acre. The taxpayers should have been getting $100 million a year. Over a 10-year period of time, the taxpayers lost between $750 million and $1 billion. I brought a series of cases in this regard, and they were all consolidated together. The judge was Judge Susan Bruguera. She received $547,232.80 in illegal payments from LA County. I brought a disqualification against her. She struck the disqualification. We took it up into an appeal. The Court of Appeal judges, all of whom were previous Superior Court judges in LA County and who had received illegal payments, dismissed our writ. And we were going forward on the grounds that there was due process, a violation of due process. Judge Bruguera, in the end, ends up dismissing the case, as one would expect, based upon the money she received, and we go up into an appeal. Now, interestingly enough, and I'm sort of fast-forwarding you on this, what happens is that based upon these illegal payments, these judges were disqualified under law immediately. And there's a case called Roscoe Holdings versus Bank of America that holds us that a disqualified judge is disqualified immediately and everything that they do is void. Now, so any of these judges are out right off the bat. The next thing that happens in 2004 is in July of 2004, I had a case which affected me personally. We had taken out a third mortgage on our house. It turned out that that was a false mortgage. We had paid it back. The person that gave it to us turned out to not be the lender, and they did a false foreclosure, and they came to evict us. We showed that the mortgage was false, that the person was not the lender, and Judge Richard Stone, who was receiving illegal money from the county, refused to allow that evidence into the court, and we lost the house, and we were evicted. Once again, another part of the retaliation by the LA County judges. In September of 2004, after we had filed this massive case, the billion-dollar case against the county in front of Judge Bruguera, it turns out that Bruce Mitchell, remember him from 1999, secretly goes to the California State Bar to file a complaint against me. Now, backtracking, this is the second complaint that is filed by the judges against me in the California State Bar. In 2003, the presiding judge of the LA Superior Court filed a complaint. The State Bar filed an action against me, and in 2004, they dismissed that action when I filed a motion after I filed a motion to dismiss on the eve of trial. So they lost the first time. I go against the county again in 2004 with the billion-dollar case. Within a short period of time, Mitchell, who's on the take, comes in and secretly files a complaint. The State Bar never mentions Mitchell at all. 3 years later, in the trial of that State Bar action, Mitchell walks into the courtroom. He's the only other person in the courtroom besides the prosecutors and me. The judge says, "Who are you?" He says, "My name is Bruce Mitchell. I'm the complaining party." I asked to put him on the stand. The State Bar asked for a recess. They get Mitchell out of the case. We never see him again. So going back to where we are in 2004, the next thing that happens in 2005, I file another case, Coalition to Save the Marina versus the County of Los Angeles. And this case seeks the same results against the County of Los Angeles and another group called Marina Pacific Associates, which is kicking boaters who live in boaters out of their docks as part of a restoration of the docks and not finding them other places to live. This case is in front of Judge Burley. Judge Burley received $637,206.38 of illegal money from the County of Los Angeles. And what becomes even more interesting now is that Sheldon Sloan is the lawyer representing Marina Pacific Associates. Marina Pacific Associates is owned by Jerry Epstein and the Epstein Family Trust. Sheldon Sloan is on the Board of Governors of the State Bar of California. He later becomes the president-elect and the president of the Board of Governors of the State Bar of California. This is while the State Bar is investigating me and later comes in and files a notice of disciplinary charges against me. January 2006, I'm retained by the Marina Strand Colony 2 Homeowners Association to fight an environmental impact report, which is filed by the Delray Shores Joint Venture and the Delray Shores Joint Venture North. Guess who's behind that? Jerry Epstein and the Epstein Family Trust. And they now want to redevelop a 200-unit apartment building in LA, in Marina Del Rey, into a 500-plus unit apartment building with 1,000 parking spaces adjacent to this condominium project. Now, the next thing that takes place is that on February 6, 2006, within a month after this retention, the State Bar files disciplinary charges against me. Good old Sheldon is up there. And who else is on the Board of Governors of the State Bar, believe it or not? A partner in a law firm called Munger, Tolles, and Olson. And what is their connection to this? Munger, Tolles, and Olson is representing LA County in negotiating an extended lease with Jerry Epstein for the property for the redevelopment of this apartment building. And this person is Jeffrey Blake. Jeffrey Blake is on the Board of Governors. Jeffrey Blake becomes the president-elect of the State Bar after Sheldon Sloan and the president of the State Bar after Sheldon Sloan. Strange how these connections take place. Neither of these people mention their connection and their interest of getting me off these matters and off these cases. The failure to mention this is a misdemeanor. Both of these people at this point are guilty of a misdemeanor. On December 26, 2006, the LA County Board of Supervisors approves this option to amend the lease agreement with Jerry Epstein. Now, an interesting thing happens here because there is a law that says that if a supervisor receives a contribution greater than $5,000 within 12 months of the time that he's supposed to vote on something for the contributor, he can't vote. He can't even argue for it. Well, guess what happened? Within the previous 12 months before this December 12, 2006 vote, Michael Antonovich received $1,000 from Jerry Epstein, $1,000 from Pat Epstein. Supervisor Burke received $1,000 from Jerry Epstein, $1,000 from David O. Levine, Jerry Epstein's chief of staff. Kanabe received $750 from David O. Levine and $300 from Marina Properties LLC, which was an Epstein company. Those votes violated the government code sections 87105, 87300 to 87302, 87313, and the case of Break Zone Billiards versus the City of Torrance. That lease, the votes were illegal. The lease was illegal because you have 5 supervisors, 3 of them received the payoffs. The vote is illegal. LA County covers this up. The supervisors cover it up. The judge covers it up. In May 15, 2007, the supervisors approve the environmental impact study. Remember the one that I got hired on back in February or January 2006? Well, it took all that time, and finally they approve it by a 4-0 vote. But what happened in April 2007? You guessed it. On April 24th, 2007, Antonovich received $1,000 from Jerry Epstein, $1,000 from Pat Epstein, and Kanabe received $1,000 from the Epstein Family Trust. It was a 4-0 vote. 2 out of the 4 received the illegal payments. The vote was illegal. Now, once again, totally covered up. On June 14th, I filed a writ of mandate seeking to overturn this approval. The case is Marina Strand Colony 2 Homeowners Association versus the County of Los Angeles. Superior Court Judge David P. Yaffe is assigned to the case. David P. Yaffe received $827,612.55 in illegal payments from LA County. He didn't disclose the payments. He didn't disqualify himself as he was required to do, and he was immediately disqualified under the Roscoe case that I mentioned before. Now, in the meantime, what is taking place is that my state bar case is going on. The hearing judge in the state bar case is a judge by the name of Richard A. Hahn. In June and July of 2007, while Judge Hahn is sitting on this case, LA County contributes $30,000 to the Southern California Special Olympics. Now, one might say that's okay, except for one thing. Sitting on the Board of Governors of the Special Olympics is Judge Richard A. Hahn. This appears to be the only contribution that LA County has ever made to the Southern California Special Olympics, either before or after. Judge Hahn does not disclose this contribution, and nor does he disqualify himself. And later, when I raise this, the state bar refuses to disqualify him. On October 12, 2007, the targeting continues under Phase 2. Judge Hahn orders that I should be involuntarily inactive and recommends that I be disbarred. Now, this becomes crucial because now what has happened is that LA County, Sheldon Sloan, Jerry Epstein, and the judges have accomplished their purpose. Being ordered inactive cuts off my income, cuts off my livelihood, stops me from practicing law, cuts off all of my resources, and effectively removes the only lawyer who is capable of fighting LA County, the developers, the judges, and the billion-dollar taxpayer cases. Coalition to Save the Marina loses its lawyer, can't find another one. In all these cases, the lawyer is gone. The only thing that happens is that in the Marina Pacific case, they find another lawyer, but that lawyer doesn't really do the same job. What then takes place is that in January 2008, Phase 3 of the targeting and retaliation begins. With the new lawyer in place in the Marina Strand case, Judge Yaffe goes in and orders, without my being present and without my knowledge, that I should pay attorney's fees in that case because the case got dismissed and reinstated. Now, what had happened is that LA County missed filing the record in the case by 60 days. I missed asking for a trial by 1 day. We each filed cross motions against each other. Judge Yaffe and I said if I was missed by 1 day, the case should be reinstated because it was a miscalculation on the number of days in August. Judge Yaffe granted the motion to dismiss, granted the motion to reinstate, and denied the motion to win the case on our behalf against the county, saying that there was no harm. So what he does is he sticks it to us and does nothing against the county because naturally he got paid. $800 and some odd thousand. And then, without my knowledge and in violation of the Constitution, goes in and says that I should pay attorney's fees. Now, I'm not even there. It's the other attorney that's now there and who does all the rest of the briefing. Well, this violates a case called In Re Rafalo, which is a United States Supreme Court case that says that if you don't have notice and if you're not at the hearing, it's unconstitutional, it's a denial of due process to do anything. That doesn't bother Yaffe at all. I hear about this, and in February 2008, I challenge Judge Yaffe, and I say, you can't do this. Furthermore, you received all of this money, and furthermore, no judge who's received any money from the county can even sit on this case. In March 20th, 2008, we have a court hearing. Judge Yaffe admits that he's getting the money from the county. First time that he's now admitting this. On March 25th, I file a statement of disqualification against him. 10 days pass, Judge Yaffe doesn't answer, and he's automatically disqualified a second time now under the statute, which is CCP section 170.3C4. April 2008, Judge Yaffe, irrespective of all these things, enters an illegal judgment for attorney fees against me, even though he's no longer a judge. On September 29th, 2008, the review department of the State Bar goes in and upholds a disbarment and recommends that I be disbarred. Now, at this point in time, something very interesting happens. In the first time before Judge Hahn never deals with the First Amendment, because in that State Bar complaint, the complaint was based only on documents that I filed in courts, which are protected by the First Amendment. Before the review department, the State Bar came in and said, in their briefs and in oral argument, that they were not prosecuting me for any document that I filed in a court, or for any statement that I made, or for any rhetoric. So they basically emasculated their entire complaint. The review department said that they were not dealing with the First Amendment, falsely claiming that it had not been raised, when in fact it was raised from the very beginning. So we now have the State Bar backing off on their complaint, and the review department going ahead for the judges and still coming against me. The next thing that happens in October 2008, literally 10 days after the review department comes out with their decision, and by the way, their decision does not become final until November 2008, so while it's still pending, in October 2008, the California Court of Appeal comes out with the case of Sturgeon versus the County of Los Angeles. That case holds that the payments by counties to the judges violate Article 6, Section 19 of the California Constitution, and that only the state legislature can prescribe the payments for the judges. And this duty is not delegable. Guess what? Same thing that I said in my cases back in 2002. Well, doesn't faze anyone. I then go on to the California Supreme Court, and I file a petition to dismiss the complaint. Supreme Court does nothing about it. And what happens, however, is that when you looked at the California Supreme Court at that particular point in time, it had 7 judges. Out of those 7 judges, 5 of them had been Superior Court judges and took illegal payments from either counties or courts during the time that they were Superior Court judges. I'm sorry, 4 of them did that. The 5th one, Judge Baxter, was on the California Judicial Council that wrote a bill called SBX 211. SBX 211 was a bill that was passed in reaction to the Sturgeon decision. What SBX 211 said in Section 5 is that it gave retroactive immunity to the judges for having received these payments. Now I'm going to read to you Section 5 because it's very interesting. It says, notwithstanding any other law, no governmental entity or officer or employee of a governmental entity, meaning a judge, shall incur any liability or shall be subject to prosecution or disciplinary action because of benefits provided to a judge under the official action of a governmental entity prior to the effective date of this act on the ground that those benefits were not authorized under law. Now, do you know what that means? The legislature has now said that these payments by the counties and the courts were criminal because they are giving them retroactive immunity from criminal prosecution. This is unheard of. In fact, literally, when you look at the history of the world, there are very, very few countries that have done this. You have Libya under Gaddafi, Egypt under Mubarak, Tunisia, some South American countries, South Africa under apartheid, some of the death squads. California stands with that small group of totalitarian nations that has wiped out the rights of its people and has given immunity from criminal prosecution to criminals on a wholesale level. And those criminals are the members of the California judiciary who have accepted these payments. I'm going to take this a step further. SBX 211 required the California Judicial Council to come up with a report on these payments. That report came out in 2009 to the state legislature. That report said that 90% of the judges in California received these illegal payments. An official report has now confirmed that 90% of the judges in California received criminal payments, effectively tagging them as criminals. That report also said that 20 counties gave these criminal payments to these 90% of the judges, and 34 courts gave these payments. That gives you an idea of what these payments were. I've been able to estimate based upon the payments because the report said how much the payments were, and it's pages D9 through D12 of the appendix of this report shows that basically the payments were $33 million a year as of the year 2007-2008. 30 million by the counties, 3 million by the courts. As of the present time, and the last thing that we saw for Los Angeles County, LA County is giving $25 million a year. From 1985 through the present, it is estimated that LA County alone has paid out over $350 million in criminal payments or illegal payments. This is the largest judicial scandal in American history. Now, going back to our California Supreme Court, 6 of the people denied my petition for review. 5 of them either got illegal payments or wrote SBX 211. The next thing that happens is the Judge Yaffe in November 2008 comes forward and he files an order to show cause for contempt and 22 counts against me. December 2008, we have a trial. This becomes one of the most interesting trials in history. Judge Yaffe, who's taken illegal payments, is sitting as the judge. Judge Yaffe is also the first witness. He is the judge and the witness. Now, this is clearly illegal. There's a case called In re Murchison that says no man can be a judge in his own case, and no man is permitted to try cases where he has an interest in the outcome. Judge Yaffe's testimony shows, and he admits that he is taking illegal payments, that he didn't put it into his political campaign, that these payments were given to him, the amount of payments is shown, and everything else. He's dead at this point in time. He's still sitting in the case. Now, by 2008 and 2009, I had exposed the money trail from the developers to the LA County supervisors, who then vote illegally on the developers' programs, from the LA County supervisors in LA County to the judges, who then decide the cases in favor of LA County. So we have the total line of the money trail. There was one other factor that comes into this. The LA County Council files annual litigation reports. The annual litigation reports at that point in time showed for the fiscal years 2005, 2006 through 2007 to 2009 that of all the cases that were filed against LA County, only 3 cases were won by a person suing LA County when an LA County judge made the decision. On an average, 650 to 850 cases per year were filed against LA County. The percentage is unbelievable. Now, these cases also affect not only regular cases against LA County, this affects every family law case. This affects child custody cases. This affects child support cases. This affects criminal cases, eminent domain cases, zoning cases. Literally every case that is existing in the court is affected by these payments. And another thing occurs. Because the judge has a duty to disclose anything that could cause a disqualification under the Canon of Judicial Ethics 3E2, and has a duty to disqualify himself under CCP section 170.1 A6, and a duty to disqualify himself under Canon 3E1, these judges have to disclose these payments and disqualify themselves. And they further have to do it because they have a duty to the integrity of the court under Canons number 1 and 2A, and they have a duty to not accept payments from any person who is appearing in front of them or likely to appear in front of them under Canon 4D1. And furthermore, under the California Constitution, section 18, they can lose their job for violating the administration and integrity of the judicial process. So any way you cut it, these judges are out for taking these payments. Even with this immunity from prosecution and the immunity from any type of removal for having taken the payments, they do not have the immunity for not having disclosed the payments and sitting on the bench. But what happens? The Commission on Judicial Performance, as we said before, isn't doing anything. So you don't have anything happening. Now, the further things that take place is that I also showed, interesting enough, by this particular point in time, that as far back as 1988, the judges and the county knew that these payments were illegal. The payments started in 1985, and I was able to discover that because when I went to the county controller and auditor and started asking for payments on particular judges, they told me that they had records back to 1988 that they could get by the computer immediately. If I wanted to go back further into 1985, it would cost so much per hour to do that. So they tagged the time that the payments really started into the mid-1980s. But in a letter dated November 10th, 1988, from Roger Whitby, Senior Assistant LA Counsel, which was approved by DeWitt Clinton, the LA Counsel, to Frank Zolan, the Clerk Executive Officer of the LA Court, it was shown that the county admitted that Article 6, Section 19 controlled, that the judges were not employees of LA County, and that the judges and the county knew that these payments were illegal. In fact, they said that the payments were being made to attract and retain qualified people to serve in LA County. Now, here's where the farce begins. You can't attract a judge to serve who's already sitting. And you can't retain a judge to serve who has to run for re-election. So you know at this point in time that the payments are a fraud. But interestingly enough, there's another little hook in here. And that is that the charter of the LA County has a little clause in its Section 4 which says that the compensation of the supervisors is the same as the compensation of the judges. So a little bit of greed comes in here. And that is, by giving the judges this extra money, the supervisors gave themselves a raise without having to go to the people. Presently, the judges are getting $57,000 a year in extra benefits. Therefore, the supervisors under this section of the county charter have given themselves an extra $57,000. The judge's salary is $178,800 a year, plus whatever state benefits they get. So the supervisors, by giving the extra $57,000 to the judges, gave themselves another $57,000. It might have been just pure greed, in addition to being able to pay off the judges to win all of these cases. Now, another thing that I was able to show during this particular period of time is that these payments are bribes. Because remember, under Section 5 of SBX 211, the legislature has now acknowledged that the payments are criminal. So we don't have to go out and prove it anymore. But basically, this had already been shown before SBX 211 because the federal law was violated. And that's the intangible right to honest services. And that's 18 U.S.C. Section 1346, which Article 6, Clause 2 of the Constitution requires the judges to obey. And in that situation, there were cases of U.S. versus Frege, U.S. versus Malkus, and U.S. versus Adams, which said that the payments by a party or an attorney appearing before the judge are bribery. And the way that they reasoned is, and this was a California case, by the way, they said, because no linkage of payment and specific official act is required under California law, and because the indictment incorporates the relevant state bribery statutes, which in turn state the elements of the bribery offenses, the indictment is valid in this respect. So what happens is that they indicted and sent to prison good old Judge Adams, California judge. Now, Judge Adams previously was removed from office in the case of Adams versus the Commission on Judicial Performance because he violated Article 6, Section 18 of the California Constitution of interfering with the integrity of the court and the judicial administration. And so basically you have the whole thing put together. And recently the U.S. Supreme Court case of Skilling versus the United States held that Section 1346 applies and is limited to bribe and kickback, then the kickback core of the pre-McNally case law, which is the holding in U.S. versus Frege. So coming back to my story, on March 4th, 2009, good old Judge Yaffe holds me in contempt of court for not answering questions about my finances related to his illegal April judgment. And what does he do? He orders me into illegal coercive incarceration. Now, this puts me for 18 months in confinement in a 7-foot by 8-foot by 13-foot cell without windows in the LA County Men's Jail to deter me from challenging the illegal payments to the judges and the illegal actions of the LA County and its co-defendants. During this period of time, I was let out approximately 10 times for 3 hours each time in the evening in a cage of 6 feet by 6 feet by 8 feet high, and approximately 5 times to watch television for approximately 1 hour, other than visits in which I was also in a cage, or passing legal papers which I was guarded, shower time during which I was locked in a shower, or visits to the medical staff. At all times when I was outside of my cell, I was accompanied by at least 2 sheriff's deputies, and many times one of them had a video camera recording our movements. During this time, the cell leaked when it rained, the toilet overflowed when another prisoner in another cell stuffed it with something for something, and for 3 months I was denied dental treatment when the brace in my mouth broke. At all times, the lights were on 24 hours a day. The cell was somewhat freezing. And to sum it all up, an article in the American Thinker magazine called my incarceration worse than the treatment at the prisoners in Guantanamo. The only thing that kept me going during this period of time is that I had to fight the unlawful incarceration in the federal court, the Ninth Circuit, and the U.S. Supreme Court. I had a 3-inch pencil and a legal pad. So I spent all my time writing these briefs, and so I was so busy writing the briefs that basically I was able to get through this by being occupied doing the fight with the briefs. On March 13th, 2010, the California Supreme Court denied my petition for review, as I mentioned earlier. On July 13th, 2010, interesting things begin to happen. I'm now in front of the United States Supreme Court. Judge Yaffe files a minute order in which he admits to making a false order in my case, and this is a crucial false order. On March 18th, 2008, Judge Yaffe claimed that I didn't have the right to challenge him. A couple of years later, on July 13th, 2010, he now says that he never made that order. Well, this throws out Judge Yaffe's entire case, because now he's saying that I did have the right to challenge him from the beginning. At this point, I was incarcerated for over 2 years, and 15 months. I'm sorry, for 15 months. I brought this up to the Supreme Court. They did nothing. On that same day, however, Judge Yaffe announced that he would be retiring or resigning before his term of office was over. On September, now I was now filing motions to get out, which were called FAR motions. I filed the motions. What happens? I get a hearing date, and the sheriff's office refuses to take me to the court for the hearing, claiming that they don't have the funds for transportation. On September 16th, which was my hearing date, Judge Yaffe comes out with an order saying that he is never going to let me out of jail. On that day, I was visited by 3 Hasidic rabbis. Now, this is the day before Kol Nidre, which is the holiest Jewish holiday. The 3 rabbis mentioned that they were going to talk to Judge Yaffe or do something. On September 17th, which was Kol Nidre, I'm in my cell, nothing is happening, and suddenly the guard, Sandoval, comes in and starts rousting my cell. And he's throwing everything all over the floor and just going crazy. And I'm saying, Sandoval, what is this craziness? What are you doing? Sandoval was a good guy. He never bothered me at all. He's just going nuts in the cell. And I'm saying, Sandoval, this is a Jewish high holiday. What is this craziness that you're doing? And finally he said, you're out. And I said, what do you mean I'm out? He said, you're out. Here's the order. And Judge Yaffe changed his mind, decided that I was never going to give in, and let me out. And in his order, he admitted that the purpose of the incarceration was to deter everyone. And he said, and I'll quote it, by keeping him incarcerated for 18 months, the court has deterred others from defying its orders to the extent that it is possible to do so under the facts of this case. Now, we look at what are the facts of this case. What is he trying to deter others from doing? The facts of the case were Judge Yaffe took approximately $827,612.55 from 1959 from LA County in illegal criminal payments. He violated the California Code of Civil Procedure, Section 170.1A6A3, the Code of Judicial Ethics, Canons 1, 2, 2A, 3E, 1 and 2, and 4D1 by taking the payments and refusing to disclose them. He violated the California Penal Code Sections 7, 92, 93, 94, 96.5, and 98, and 182A5, amongst others, by taking the bribe and by making decisions in favor of LA County and by colluding with LA County to pervert and obstruct justice by concealing the payments. He violated the federal criminal laws of the intangible right to honest services, 18 U.S.C. Section 1346, the conspiracy against rights, 18 U.S.C. Section 241, retaliating against a witness, a victim, or informant, 18 U.S.C. Section 1513. He violated due process by deciding the case himself of case of In re Murchison. He violated Article 6, Section 19 of the California Constitution. He was disqualified from the outset because of the illegal payments, making all of his decisions void. And that's the Roscoe case. He knew at all times that he committed fraud upon the court by stating that he issued an order on March 18th stating that I did not have standing to challenge him when he knew he never issued that order. And then, most important, the order and judgment of contempt dated March 4th was false, as it held me in contempt for disobedience of a lawful judgment and sentenced me to jail for coercive confinement under CCP Section 1209A5. But 18 months later, on September 17th, his order states, as of the date of this order, fine is to commence serving the 5-day criminal sentence he was ordered to serve for contempt of court. Now, there was no criminal sentence in the March 4th order. The only thing that he had in the March 4th order, in addition to the coercive confinement, was to pay $1,000 fine or serve 5 days in jail for practicing law without a license on the involuntary enrollment. That was an either order. It didn't say both. So now he's come up with an order to serve 5 days criminally. So basically what happened is that he committed a fraud on March 4th, which he didn't say that he had sentenced me to 5 days. Well, if I was sentenced to 5 days for not answering the questions, my sentence would have been 5 days and I would have been out. So what did he do? He lied. Straight out and out lied. And what is the result of that? Judge Yaffe and the LA County Sheriff illegally held me in coercive confinement for the entire time, from day one. Now, Judge Yaffe retired in September before completing his office, or resigned, either way you want to put it. And I filed a notice of void orders on July 22nd, 2011, and an amended notice of illegal incarceration on July 20th, 2012. Things are now breaking apart. On August 30th, 2011, the California State Bar admitted that my disbarment was a fraud by claiming that I was disbarred for filing what they said frivolous cases against the judges regarding the illegal payments. Now, this is very interesting. They never charged me with that. So basically, they now admit that I was disbarred for a reason for which I was never charged. In December 2011, I filed my motion to set aside the void disbarment. The California State Bar does not oppose it. And as I said before, the judges are still retaliating. That's the final phase of our retaliation. They're still maintaining the fraud upon the court because they were on the take. And that keeps going. So the current status that we now have is that the judges who received illegal payments are retiring midterm as Judge Yaffe or are recusing themselves. Examples are Judge Yaffe California Supreme Court Justice George, Associate Supreme Court Justice Moreno, both who were former LA Superior Court judges and according to their biographies received the illegal payments. And we have various judges in the Marina Strand case who recused themselves, as Judge Chalfant, remember him, same judge as back in the old Silva case. We have Judge Burley, who, same judge, back in the other Marina cases, and a number of others. So we have a situation where you have judges who are in the situation of the following quote, and that is, power tends to corrupt, and absolute power corrupts absolutely. And that's John Emmerich Edward Dalbert Acton, the first Baron of Acton, 1834 to 1902. What we have is we have a situation in the judiciary where the judiciary actually has absolute power due to lack of pressure upon the judges by people enforcing their rights and the lack of enforcement of existing laws by our prosecutors. Now let me explain this a little bit to you. The judiciary is the only branch which self-regulates itself when you look at it. Judges decide themselves if they should disqualify themselves from cases. There isn't an outside board that makes this decision. This is done either by self-disqualification or by a second judge deciding upon the disqualification of the first judge. Either way, the process is a judge deciding upon the disqualification of a judge. No third-party objective person is involved. Now, in contrast, if a high crime or a misdemeanor occurs, impeachment may occur. However, impeachment is rare. In the history of the United States, only 17 federal judges were impeached. 14 were convicted and 3 resigned prior to the trial in the Senate. In the states, among 35,500 judges who are presently sitting, the history of the states, none were impeached. Another form of removal of state judges is by the state legislature. No state judge appears to have been impeached by a state legislature. The third form of removal is by a commission on judicial performance or such other body. These removals are rare, as these bodies usually are comprised of judges, attorneys, or other people appointed by judges or state legislatures. Therefore, and these people actually have an interest in preserving, the judges. Therefore, removing only is occurring in most egregious cases which affront the public. Interestingly enough, the most recent report of the California Commission on Judicial Performance showed approximately 1,000 complaints during the last year, no removals, and 1 letter of reprimand. Basically, this is outrageous. However, a judge taking money from a party appearing before him was removed, and this is the case of Adams versus the Commission on Judicial Performance, and this was back in 1995, where a judge accepted gifts, financial benefits, and favors from an attorney and a litigant appearing in the judge's court, and that required his disqualification with respect to matters involving these attorneys or their firms. And this cited the case of Adams on judicial performance, which said, conduct prejudicial to the administration of justice that brings the judicial office into disrepute. So, our judges who are taking these illegal criminal payments from LA County, who is appearing in front of them under the precedents, should be removed, kicked out of office, prosecuted, and go to jail. These are the precedents that are existing. The only thing that is stopping them is the lack of enforcement by the Commission on Judicial Performance or the district attorneys. Now, the final form of removal is election. And in 39 states, the judges are elected. some with retention elections where the judge's name is on the ballot and you vote yes or no, or others where, as in California, the Superior Court judges may be challenged. But as I stated earlier, out of the 150 judges that were up for re-election, 125 of them were not challenged. You didn't even see their names on the ballot. So basically, we, the public, don't even know who's running. And with respect to the enforcement by laws, as I mentioned earlier, I filed the complaint to the Attorney General, California Attorney General, D.A. Cooley, the U.S. Attorney. Nothing happened. So what we have is when speaking of the judiciary, power tends to corrupt. Absolute power corrupts absolutely. However, don't be disappointed. There's another adage that exists, and that is for us. And the adage is, never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it is the only thing that ever has. That's Margaret Mead, anthropologist, 1901 to 1978. We can combat the illegal payments and their pernicious effect by understanding them, their cause, their effect, and the methods to combat them. At this point, you can understand California has the most corrupt judiciary in the United States, if not the world. Now, with respect to judges like our judges who have become federal judges, the recent case of Judge Porteous in New Orleans, who became the 17th judge to be impeached and the 15th to be convicted, his crime was taking payments from parties appearing before him while a state judge. When he became a federal judge, and he didn't talk about this in his proceedings to become a federal judge, he got impeached and they got rid of him. So we know that if our state judges become federal judges, they could actually be impeached. As I said before, in California, they're in that small group of people who are protected like those in the totalitarian world. But we know that this small group of people have removed our constitutional right to a fair judiciary, creating the largest scandal in history. Now, when we look back to the LA scheme, what really occurred is that starting from 1985 onwards, LA and the judges engaged in this scheme to pervert and obstruct justice, violate the First, Fifth, and 14th Amendments to the U.S. Constitution, violate sections 241, 1513, 1346, articles, the California Constitution, Article 1, sections 1, 3, 4, 7, Article 6, sections 17, 19, and 20, and the California Code of Civil Procedure, sections 17.1A, 6A, the Code of Judicial Ethics, canons 2, 2A, 3E, 1 and 2, 4D1, and violate the California Penal Code sections 7, 92, 93, 94, 96.5, 98, 182A5, A5, amongst others. That's a lot. Tremendous amount. And LA County performed this by paying the bribes to the state elected judges. And the judges went along with it by refusing to disclose these payments, and LA County went along with them by refusing to disclose the payments also. And we showed that the LA County supervisors got their little kick out of it. Now, as a financial part, the result ends up being that our LA County judges are being paid more than the U.S. Supreme Court judges. The LA County judges are now taking home approximately $250,000 a year. The Chief Justice of the United States Supreme Court only takes home $234,000 a year. Very interesting what criminal payments can do. So what we have in the end is that we have to put the pressure on. We have to put the pressure on in two ways. At the federal level, a federal judge can be disqualified under 28 U.S.C. section 144 or 455 by forcing his disqualification. Only we, the people, can put that out there and force those motions to occur. At the state level, we have to go in and force the disqualifications to occur by forcing the judges to go in and admit to these payments immediately the first minute that we walk into that courtroom. And when the judge doesn't, we start raising the issue of fraud upon the court and the immediate disqualification of the judges. And that everything they say is going to be void, because when we do that, we've raised the issue of due process right from the start. What Judge Yaffe tried to do to me in his contempt order is he tried to say, well, Mr. Fine didn't raise the issue that I was disqualified early in the game. Of course, Judge Yaffe was covering up the fact that he was mandatorily disqualified from the very beginning because of the fact that he took the illegal payment, and under the Roscoe case he was out. He didn't think that I knew that. And that's what knocked him out, and that's what knocks every judge out, because they don't tell you right off the bat that they've taken the illegal payments. And that's how we knock these judges out. So that's the pressure that each and every one of us must do immediately. And if our lawyers don't do it, then we get in there and do it. We put that pressure on them. We put that pressure on them in every case. And as long as we keep putting that pressure on them, the system can't handle it. They can't handle it. When they see that coming against them in every case that they are in, and they see our knowledge of the law coming against them in every case that they are in, sooner or later, they break. They retire, they resign, they can't handle it. With this information, we become able to exercise our rights. And we fulfill Margaret Mead's saying, never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it is the only thing that ever has. But more than that, we still need a little bit more. We have legislation in place, but we need one more thing in addition to some other things. But one thing is to remove the ability of the judge and the judges to decide on their disqualifications. As long as they're the ones deciding, we have a problem. So we need legislation to remove that ability from the judges and put that decision in an objective place where the judges can't get to the decision maker. Take it out of the judiciary. Put it into an objective board where the judges can't get to that board, and where the legislature can't get to that board, and where the executive can't get to that board. That's the type of new legislation that we need. And then finally, I leave you with one thought after all that has occurred to me. Judge Yaffe resigned. Chief Justice George resigned. Associate Justice Moreno resigned. Various judges are now recusing themselves. Yet, I am still here speaking to you. Thank you. All right. God bless all of you, and God bless America. Okay. When you filed all of your papers and you've been, shall we say, destroyed by members of the judiciary, the only thing that you can do is keep running the case all the way up through the local Supreme Court or the local state Supreme Court and set the case up so that you can find a fraud upon the court by the local judges. Now, what this really means is that from the very beginning of your case, you have to construct your case in such a way that the judge is going to be committing what we call an extrinsic fraud upon the court. And to put it in a context that we can use here, let's take California. In California, we know that the judges are receiving illegal payments. So the minute that you have a case assigned to you, the first thing that you're going to do, or that I would suggest you do, is you get to the auditor controller and you find out how much money the judge has received. You'll usually be able to find that out within a couple of days or a week at the most. And this will be before you have your first hearing. At the first hearing of the case, the judge is required to, first of all, tell you if he has received any money from either a party or a party's attorney in his last campaign. Now, this is California Code of Civil Procedure section 170.1A9, A, B, and C. Section C part says that he has to disclose if he has received any money from the party or the party's attorney in his last campaign or his current campaign. Section A says that if he's received $1,500 or more, he must recuse himself. Section B says if he's received less than $1,500, he must recuse himself if an ordinary person would consider that there could be a problem. Okay, so number one, what you're going to do is you're going to go, when you get your judge assigned, you're going to go to the Secretary of State's office online, and you go to the part about elections, to the part of candidates, you plug in the judge's name, you'll get his campaign contributions, and you'll look to see if there are any contributions. Number two, you're going to go to the auditor controller's office, and you're going to find out, if the judge received any money and how much it is. On your first appearance to the judge, if the judge got any of these campaign contributions and he doesn't disclose it, and they're above $1,500 or they're close to $1,500, you're going to knock him out. If the judge doesn't go out at that point, you're going to raise the issue and you're going to force him out through the Court of Appeals. He doesn't have much of a choice here. He's going to be gone. If he doesn't go, that's a denial of due process. And if other judges go along with not taking him out, you will have the necessary fraud upon the court that even if the California Supreme Court denies your rights, you then come into the United States District Court under a fraud upon the court and under a case called Kogosian, at which point you've established a fraud upon the court and you can bring your case in the district court. That's one way of doing it. And then you're running it through the district courts as to whether you're going to be caught there by dishonest judges. The second thing is to do this with the judge on having received payments, running it exactly the same way. And in this, even if you don't have a case against the county, the judge still has to disclose that he has taken illegal payments because he has violated the integrity of the court and he's violated the administration of justice by having taken criminal payments and received retroactive immunity. So basically this puts him in a position that he is not really a person capable of sitting on your case because his integrity is impaired. And so therefore he has a duty to tell you that under Canons 3E1 and disqualify himself under Canon 3E2. So these are the methods that you can use. Now, these things have not really been used before. And this last one that I'm coming up with his duty to be able to tell you that he's received the retroactive immunity, even though it's been from the county and everything, and going to his integrity is something that people have not tried before. But yet, when you look at the law, he should be out. So this is the type of thing that you can do. Now, I don't know what will be happening with this, but if everyone starts doing it and then starts going into the federal courts with this, sooner or later, the system will not be able to deal with all of these people enforcing the law. I'm going to take you to another subject here, and this is something that I didn't cover in my previous testimony, and that is that with respect to these illegal payments, there is part of the law that says that the district attorney had to enforce against the judges a collection action for all of the illegal payments plus 20%. District Attorney Cooley And every district attorney in California, in the 20 counties that were paying those illegal payments, did not do that. But this is the law, and it was Penal Code Section 26522 or 26525, and specifically states that the district attorney shall do that. So basically, these are the things that you have. Yes, in the I don't remember exactly in which particular interview that I made that comment, but it is true. I did call and do call for a citizen army, basically to be led by Bill Windsor and others, to go out and enforce these laws, to bring the pressure upon the judges, the legislators, state legislators, our Congress people, and our executive, because this is the only way at this point in time that we are going to effect change. Now, interestingly enough, the United States has a revolution every 2 years. The revolution occurs at the ballot box. We basically change over a government. However, in between that period of time, we also have a continuing revolution. And that continuing revolution is citizen pressure to be placed upon elected officials, and in the case of the judiciary, who we can now show are people attempting to achieve absolute power, the removal of that absolute power. Their power is existing because our officials are not enforcing the law, so therefore we must step in and use all available procedures to us to enforce the law. The system is there, the procedures are there, and the only reason that they have not been used is because we, the people, we, the citizens' army, were unaware of our weapons. We are now becoming aware of our weapons, and I advocate that we use our legal weapons to gain and restore our rights. In answer to a question as to whether I would classify this as a new civil rights movement, my answer would be no. I classify this as the continuation of the ongoing civil rights movement that started in 1776, continued in 1789 with the drafting of our Constitution, and has been ongoing throughout the history of the United States. What happens every once in a while is that people get lulled into a place of complacency. However, when others attempt to establish totalitarianism and remove our liberties and our rights, the people of the United States tend to wake up. So this is not a new civil rights movement. This is just a reawakening of that movement that has always existed in this country. Yeah. In response to the question of an original petition to the United States Supreme Court where the jurisdiction is mandatory and the Supreme Court does not have the ability to resist through discretion, and the answer is that we refuse. This means that the Supreme Court is effectively establishing a precedent that it is refusing to enforce the laws of the United States based upon their precedents. Now, Effectively, that means that the Supreme Court has taken a position in its original jurisdiction that it is denying its previous precedents. Effectively, it is doing that, but yet by not publishing its decision, it is attempting to hide the decision from the public. So the whole issue becomes, is the petition one in which the Supreme Court has mandatory jurisdiction, or is it a petition for writ of certiorari where it has discretionary jurisdiction? If in fact it did have mandatory jurisdiction, then its decision is one that is very dangerous, because it in fact has gone ahead and denied its precedents. Many times where it has discretionary jurisdiction, such as a writ of certiorari, there's a long history of its denying its precedents by just going forward and denying the petition and saying to the particular petitioner, forget it, we could care less about our precedents, we're just not going to do it for you. In this situation, it becomes a lot more dangerous. Okay. With respect to a citizen's rights to directly bring an issue to a grand jury, I have to admit that I'm not directly familiar with the exact law because I haven't read it. Now, usually what does happen is that there should be direct access by a citizen to a grand jury. There should not be a filter to the grand jury itself. What happens in practice is that the district attorney ends up being the counsel to the grand jury, and then the grand jury usually cannot indict without the district attorney also signing the indictment. In practice, what happens is that the district attorney is actually the one that actually writes the indictment, and then presents it to the grand jury, and the grand jury actually then votes on the indictment, calling it a true bill or not. I'm not sure as to whether the district attorney is acting as a filter for the grand jury, and whether the statute sets it up for him to act as a filter. My basic belief is that usually the district attorney is not allowed to act as a filter to the grand jury, and that information to the grand jury should be able to get there either through the judge or in some form directly to the grand jury through the court system. But as I say, I don't have the exact answer to that. But since the grand jury is in fact an institution of the court and not of the prosecutor's office, I would expect that any information to the grand jury should be able to go through the court. However, I have seen instances where people have tried to put information to the grand jury through the court, and that information has in fact been returned because of the fact that it did not go through the district attorney, and the district attorney has actually acted as a blocking mechanism. But I have not seen any cases where someone has brought up the issue to be litigated as to whether the district attorney is an official blocking mechanism or not. So unfortunately, I don't have a direct answer to your question. Okay, when I was with the Justice Department, I worked with federal grand juries. The federal grand jury was constituted by the U.S. District Court. This was in New York. The U.S. District Court called the grand jury, and the grand jury was actually chosen by the U.S. District Court. We, as the Justice Department lawyers, presented evidence to the grand jury, and we issued subpoenas, in the name of the grand jury. The people came to the grand jury. They went into the grand jury room. They were not under the grand jury system. They do not have a counsel in the grand jury room. Their counsel was actually outside the door, and the counsel debriefed them the minute that they walked outside the door. These were antitrust grand juries. These were very, very sophisticated people. what occurred after all the testimony was in, the Justice Department then decided as to whether we were going to recommend an indictment or not. And then after that took place, we would present, a summary of all of the evidence to the grand jury, and then the grand jury, and we would present a proposed indictment. The grand jury then would go forward and decide whether they wanted to indict or not, and that was their decision. Realistically speaking, after hearing all of the evidence, the grand jury would usually be willing to indict because they heard a tremendous amount of evidence. But these were unusual grand juries because they ran between 30 and 40 days of 8 hours a day, hearing evidence. And these people were very, I would say, although they were ordinary people in the sense that they were average individuals, by the time they got finished, they were really quite sophisticated in what they were listening to. And they knew how to separate the wheat from the chaff, as one would say. That grand jury experience is different from, well, I would say, is a normal grand jury where a DA comes in and, with an hour or two tries to present something to the grand jury and say, look, I want you to indict. In the antitrust world, in order to get an indictment through in a major case, it went all the way up to the White House. An ordinary DA is going to take his shot and just go forward and probably bring charges which are greater than what actually happened. In the case of the antitrust division, we were very, very conservative in the charges that we brought, and this is by 1968 to 72. We didn't lose too many cases. Okay. The question was, did Judge Yaffe ever rule on any motion to disqualify him? And the answer is no. What occurred is that after Judge Yaffe admitted on March 20th, 2008 that he was taking illegal payments, on March 25th, 2008, I filed a statement of disqualification under CCP section 170.3. 10 days passed. I served that on Judge Yaffe. 10 days passed, and Judge Yaffe did not file an answer to that. In fact, he never filed an answer to that. Under the law, under CCP section 170.3 C4, he was automatically disqualified. Judge Yaffe never sent the file to the presiding judge to have the case reassigned. And I then later on went down to the presiding judge's office, and I filed a motion to have the case reassigned. In the presiding judge's office, Judge Yaffe was, I think he was on leave or something, or that period of time, or on a vacation. The presiding judge didn't do anything about it either. And the case still ends up back in Judge Yaffe's court. He ends up doing his order to show cause re contempt, holds me in contempt and everything else. Subsequent to that, I come in with a motion to void everything that Judge Yaffe has done. Other judges, Judge Jones, Judge Chalfant, Judge Burley, all disqualify themselves. Ultimately, it gets assigned to Judge O'Brien, who was a retired judge, but he had taken $200 and some odd thousand in payments. He attempts to deny the motions. I nail him with a notice that everything he has done is void. That's one of the notices that I mentioned, and nobody does anything to reverse that, and that becomes the end of the story. So everything that Judge Yaffe did ends up being void. One, because he never was the judge in the beginning due to his having taken the payments and not disclosed them, and second of all, because he never ended up responding to the statement of disqualification, which was his second disqualification. And then third of all, because he ended up violating in Ray Murchison by deciding his own case. So that was the story. Yaffe never at any point in time disputed that he was disqualified. The only thing that he ever said was in the order in judgment of contempt, he claimed that I should have disqualified him in the very beginning. However, that chance never occurred because I never had a hearing in front of Judge Yaffe until March of 2008. Well, I was in the original case way back in 2007. We never had a hearing in front of Judge Yaffe. I was out of the case before there was even a hearing in front of Judge Yaffe, and he was under the duty in the very beginning to disqualify himself because he had taken illegal payments.
And since he issued nothing but void orders, he lacked jurisdiction, and am I correct, he therefore does not have immunity from a civil action?
Well, actually what happens under this is that this is true because he did not have jurisdiction. The court doesn't have jurisdiction. The issue as to whether you can sue a judge or not becomes very, very interesting. There's no question that he can be sued for injunctive relief. The question as to whether he can be sued for damages is going to be a little bit more hazy because of the fact that when you look at that type of immunity, if he's acting in an administrative capacity, he could be sued. If he's acting in any type of a judicial capacity, he cannot be sued. The question now, and if he's acting in a criminal capacity, he definitely can be sued. So in order to bring this type of a suit, one would have to show that he is acting in a criminal capacity. The question now is going to come as to whether SBX 211 is going to cover him with retroactive immunity from civil liability for being sued based upon having taken payments from the county. And that's now going to be the question as to how wide that retroactive immunity is going to go for his civil liability.